most rules an enterprise lives by were written for systems that did what they were told. A regulator could ask to see the procedure, test it once, and trust that it would behave the same way on the 1000th case as on the first. A system that acts on its own varies its reasoning and decides that machine speed does not fit that picture, and regulators have noticed. The response taking shape across the major jurisdictions is not a single rule book, but a shared instinct. Match the weight of the rules to the weight of what the system can do and to the harm it can cause when it is wrong. By the end of this module, you will be able to map the major frameworks and turn divergent rules into one operating demand. This is the risk-based model, and it sits underneath almost every serious framework you will meet. A system that recommends a film and a system that screens a payment or sorts a job application are not governed the same way because the cost of a bad decision is not the same. The first carries little consequence and attracts little obligation. The second touches a person's money, livelihood, or rights, and the obligations rise to match. A record of how it was built, evidence that it works, a human who can be reached, a way to contest the outcome. What a regulator weighs is not whether an enterprise uses AI, but what the AI is allowed to decide and how much rests on it being right. Read that way, the regulatory surface lines up almost exactly with the questions we have already raised. A rule that an enterprise must show how a high consequence system reaches its decisions is the boundary written into law. A rule that the system must be tested against the cases it can harm is the tolerance, made a legal obligation. A rule that a named accountable person must answer for it is the ownership requirement enforced from outside. The regulator is not inventing a new discipline. It is insisting with the force of law on the same governance an enterprise would need to run these systems safely in any case. So no leader needs to hold the whole map. What you need is to see its shape so that when a system is proposed, you can tell early which tier it lands in and what that will require. A leader reading about AI regulation meets a wall of names quickly. They look like competitors as though you had to pick one. They are not. They sit at different heights and do different jobs, and the useful first step is to see what kind of instrument each one is. The first kind is law, a statute that applies because you operate in a territory, carries legal force, and is enforced by an authority that can fine or stop you. The European Union's AI Act is the clearest example, writing the risk-based idea into hard tiers, banning a small set of users outright, placing heavy obligations on a defined class of high-consequence systems and leaving the rest largely free. What matters is the logic. The law decides how much it cares about a system by what that system is allowed to do. The second kind is a framework, not a law, but a method, a structured way to identify, measure, and manage the risks a system carries. The NIST AI Risk Management Framework is a well-known example. It compels no one on its own. Its authority comes from being sound and widely adopted, and from regulators and customers treating it as the reasonable standard of care. The third kind is a management system standard, the same species as the quality and information security standards an enterprise may already hold. ISO/IEC 42000 and 1 is the recognized one for AI. It does not judge any single decision. It asks whether the organization has a working system for governing AI at all, and it can be certified, turning "we govern our AI well" from a claim into something an independent body has audited. And above all three sit international principles, such as those agreed through the OECD, shaping the direction jurisdictions drift in even where they are not themselves binding. So, a leader does not choose among these, so much as locate the enterprise within them, bound by the laws of the territories it operates in, governing by a recognized method, and able, where it matters, to prove it. But there is a trap, and it is worth naming. It is possible to collect the frameworks, cite the standard, map every clause, and still not govern a single system well. A system can pass a documentation review and still act outside the boundary you meant to give it, because the paperwork describes the intent and the running system is what actually decides. The frameworks are the external demand. Meeting it on paper is the beginning of governance, not the proof of it. Next, the rule that binds before any AI law speaks: data protection.